Hello, everyone. Welcome to Holland Knight's CPA webinar series. Thank you for taking the time to join us today as our panelists discuss the issues of attorney-client privilege in the context of tax return advice. Just a little housekeeping before we get started. Everyone is muted, so if you have any questions during the presentation, please type them into the chat box. We will answer questions as we go, and we should have time for Q&A at the end. I will be adding the link for the CLE request form in the chat box, and Jim will read out the code about halfway through the presentation. Please reach out to myself or any of our speakers if you'd like to receive the recording or any materials from today's presentation. So without further ado, let me hand it over to Jim for a brief introduction of our panelists.
Well, first of all, good afternoon, good morning, depending where you are. I had the privilege of being in this conference with Denise and Chris. So let me first introduce Denise. Denise is a partner in the Holland Knight Dallas office. She focuses her practice on representing individual and entities in all stages of federal civil tax disputes. She has been involved in various high-profile cases, and she is one of Holland Knight's in-house experts on privilege matters. Chris is a member of Caplin Drysdale. He guides clients through IRS audits, prepares administrative claims and protests of IRS actions, and litigates tax and tax-related cases in U.S. District and Appellate Courts, the U.S. Court of Federal Claims, and the U.S. Tax Court. In recent years, he has represented numerous taxpayers, financial entities, and professional firms in connection with IRS examination of tax shelters and related compliance and professional ethics issues. Simply stated, Chris is recognized as one of the finest tax litigators in the country. As for me, I'm an old-fashioned tax litigator. My practice focuses on representing corporation and individual taxpayers in federal tax audits and federal tax litigation. I worked for the Office of Chief Counsel for 13 years and 11 years at NextEra Energy, Inc., handling its tax and Section 1603 litigation. Be it at the IRS or in the company, privilege was a priority. Either pierce it or preserve it. That was the ultimate goal. If we can switch to the next slide, please. So what we're going to be doing today is talking about the basics of attorney-client privilege, more important, return preparation, waiver, and of course, what we're here for, in re grand jury. So if we can go to slide 3 and then 4. So let's get into the basics of attorney-client privilege. What is the policy behind attorney-client privilege? Well, it was stated in Upjohn. And Upjohn, what I want you to think about when we're talking about Upjohn is how does this work with the practice of tax? Well, the policy as to attorney-client privilege was to encourage full and frank communication between attorney and clients, to promote broader public interest in the observance of law and administrative justice. But what was the context? Well, in Upjohn, the communications were made by company employees to company attorneys during an attorney-led internal investigation that was undertaken to ensure the company is compliant with the law. The court ruled that privilege applied to the internal investigation and covered the communications between the company employees and the company attorneys. The court explained that the attorney-client privilege for business organization was essential in light of the vast and complicated array of regulatory legislation confronting the modern corporation, which required corporations to constantly go to lawyers to find out how to obey the law. The court stated that the attorney-client privilege exists to protect not only the giving of professional advice to those who can act on it, but also the giving of information to the lawyer to enable him to give sound and informed advice. That is, the court said, because the first step in the resolution of any legal problem is ascertaining the factual background and sifting through the facts with an eye to the legally relevant. Query is what was stated in Upjohn, is that necessary for the practice of tax? And to get into a little bit more about the attorney-client privilege, I'm going to turn over it to Denise. Denise, take it away. Please turn to slide 5.
Sure. Thank you, Jim. So happy to be here today with everyone. And dive into these issues, which are fascinating and very important to most of our practices, if not all of us. And so thank you for that introduction. As we talk about attorney-client privilege, many of you know what it is, know how it works, but it's really the finer details that make it into court and obviously made it into this case. And so we want to move to slide 5 and look at the classic formulation of the attorney-client privilege and the various elements that generally come from Wigmore on evidence. And I'm going to read some of the important pieces of what attorney-client privilege is, and that's legal advice that's sought from a professional in that capacity. I'm not reading it word for word. The communications which are related to that purpose that are made in confidence, that becomes a very big piece for what we're talking about today, made in confidence and at his instance, permanently protected, so intended to be kept confident, from disclosure by himself or the advisor, except for the protection be waived. And that piece is also important there, that the waiver is an element of asserting the privilege. Many of you know that, and it comes up in many cases. Moving on to slide 6, there's cases that address all of these elements, a myriad of cases getting into the details of what these elements are, were they established or not. And some of the issues that come up, particularly here in the tax context, the issues we face, for example, are whether we have a non-legal purpose, whether there was a legal advice or non-legal advice, which wouldn't satisfy that first element of attorney-client privilege. And then that last element of whether it was waived, whether it was intended to be confidential to begin with. And so we also want to note here that we see Covell and the Covell privilege come up quite a bit in the tax cases, and it's certainly a useful tool for taxpayers. It's an extension of attorney-client privilege, actually, where non-lawyers are assisting a lawyer. And so the assertion is still privileged through Covell. Covell will protect an accountant or an appraiser or translator or someone who is working in the role of an agent assisting an attorney in providing legal advice. And so that's how Covell plays in here. Moving on to the basics of the tax practitioner privilege, I'm going to hand that over to Chris.
Yeah, before we leave this slide, let me just add a couple of comments. But first, I want to thank everybody at Holland Knight for inviting me to chip in on this and crash your party. Thank you very much for that. One of the things that this slide, kind of, to be blunt, focuses us on for the rest of the discussion is tax advice legal advice? And I think, unfortunately, there's a lot of confusion over that out there in the world. It actually has been repeatedly held to be legal advice, as one would expect it if lawyers are doing it. But if non-lawyers are doing it, it can't be legal advice by definition. They're not authorized to practice law. And that is what actually leads to the next slide, if we could, because there's, in recognition of that fact, and in recognition of the fact that people in the accounting firms in particular, but other practitioners out there, were giving advice with respect to tax issues, Congress enacted a tax practitioner privilege in 1998. And that's because there's no common law privilege, and there's several Supreme Court cases on that. Arthur Young is the principal one. Some states do have modest statutory versions of an accountant-client privilege, but the accounting firms wanted to be able to have the same kinds of communications that Denise and Jim and I have with our clients about tax issues. So they enacted legislation to extend a type of privilege to federally authorized tax practitioners. And that's a term of art, which if we go to the next slide, we can discuss a little bit. The elements of the statute are that with respect to tax advice, the same protections that would be of confidentiality that would extend to attorney-client communications, extend to tax communications to the extent they would be considered privileged if it were between a taxpayer and attorney. Now, let me stop you right there for just a second, because to the extent if I was wearing a different hat, it would be privileged because then it would be legal advice, right? If you're a lawyer in an accounting firm and you switch to a law firm, all of a sudden you're offering legal advice. If you're doing that in an accounting firm, you're not doing legal advice because you're not engaged in the practice of law, even though it could be the exact same advice. Now, I always thought that for some practitioners, like a CPA who's never authorized to give legal advice, this kind of created an empty set. Since they couldn't give legal advice, even if they were in a law firm, they can't give legal advice over here. And it's not clear that tax advice is covered because they're not able to give legal advice at all. And that's what that last clause was kind of there to cover, to the extent that we're going to pretend if it were a lawyer practicing law and the same thing was said, it's going to be privileged. But if it's someone who's a non-lawyer and still doing tax advice, whatever that is, we'll get to that in a moment, it's going to be privileged. I'm not really sure that answered the question, partly because of the next slide. The way tax advice is defined is something that's done by a federally authorized tax practitioner that's within the scope of that individual's authority to practice. Now, federally authorized tax practitioner is a defined term in the U.S. Code. It's actually in the banking title. It's not in Title 26 where the Internal Revenue Code is. And it says that a federally authorized tax practitioner in 330 is a lawyer or a CPA, and the IRS has extended that in Circular 230 and to cover enrolled agents. It's not return preparers who are quote unquote just return preparers if they don't meet those other criteria. But if you're a licensed lawyer, you can be a federally authorized tax practitioner, even if you're in a non-tax attorney kind of practice, not a non-legal practice. And likewise, if you're a CPA, you can be a federally authorized tax practitioner. But then there's a catch. It has to be someone who's regulated or subject to regulation under that provision of Title 31, and it has to be within the scope of that authority to practice. So let's go to the next slide. There were a lot of exceptions carved into this, and we put them on this slide just so you see how narrow the privilege was intended to be. It doesn't apply in criminal cases. That's largely because during the drafting, it was discussed, you really want to have that applied in criminal cases? And politically, that was a little bit of a hot button, so people said no. It doesn't apply in state proceedings because obviously the federal government can't write a state privilege. It doesn't apply in other non-tax proceedings like an SEC investigation or a DOJ or a FTC investigation or something like that. Doesn't apply in criminal cases, as I mentioned. It doesn't apply to written communications with respect to a tax shelter, which is defined by reference to the standard in 6662 C2D2, I think it is, which is a transaction plan or arrangement, a significant purpose of which is the avoidance or evasion of federal tax. It's a mouthful, but it doesn't apply with respect to written communications about that. And that's a lot of communications that a lot of tax advisors do if you take a broad definition of a transaction plan or arrangement, a significant purpose of which is of the avoidance of taxes. I mean, you could say even a very routine 1031, for example. Is that a tax shelter? Well, most of us don't think that way, but if you took a really broad view of the language, you could argue it. So I think this was really aimed at mass marketed tax shelters of the sort we were seeing in the late 1990s and early 2000s, but the language is pretty vague. And like the attorney-client privilege, once it's waived for all purposes. So if the accountant in question, say, is asked to testify in FTC proceeding or in a state court proceeding and does so, that's going to waive the privilege in a subsequent IRS proceeding, even though it might otherwise be privileged. So it's not a real strong privilege, and it was even slightly weakened by something mentioned on the next slide, which is, oops, I take it back. I guess we're going to get there in a second.
Before we leave that one, I got one question for both Chris and Denise. When I teach the class at FAU, which, by the way, they made the Final Four, master's class, I like to tell the accountants in the room, welcome to the practice of law. Chris, Denise, do you agree with that statement? Or am I making something out of nothing?
Well, it is kind of strange to say, I'm doing this one thing in a law firm practice, and it's the practice of law. And if I do the exact same thing while not holding myself out to be engaged in the practice of law, it's not the practice of law, is a little bit strange. And that has been remarked upon by, shall we say, by a lot of lawyers who work in non-law firm contexts like accounting firms. Denise, what do you think of that?
Yeah, I would be cautious to indicate that they were practicing law. I think they are not practicing law. It certainly looks a lot like it, and tax law and tax accounting are very similar, and hard to draw that line.
Right. Well, I the reason I say that, and we're going to get, I think that's one of the crux of the issues in the case that we'll get to. But the reason I say that is very similar. An accountant is asked to read a statute, and an accountant is asked to read the regulation, an accountant is asked to read the case law, an accountant is asked to interpret case law, statute, regulations. And that's us as lawyers, that's what we do. But this is to set the stage, the foundation for what we see was a fundamental problem that was facing the court in the Ray grand jury. So
let me just add one point to that. Although it seems strange to say that one is the practice of law and one isn't.
Mm-hmm.
The ABA and the AICPA reached a treaty on that issue about 50 years ago,
mm-hmm.
where they basically said, well, we're not going to say it is, said the ABA, we're not going to try and enforce the ethics rules against or the unauthorized practice rules against non-lawyers. But I've always thought that while that was, like many treaties, good for the peace, it didn't make an awful lot of coherent sense.
100% in agreement. And I think that's one of the fundamental problems that the Supreme Court was facing in the Ray grand jury without being uttered. So on to the next slide. And this will turn over again to Denise.
Sure. Yeah. So we just, for completion purposes, as we're talking about whether documents and communications are privileged, we want to also include a discussion about work product as a protection against the disclosure of documents. Oftentimes, tax advice is also work product protected, in addition to the attorney-client privilege or tax practitioner privilege. And that's because work product is documentation prepared in the anticipation of litigation. And it's defined differently. I'm saying that broadly. It is codified in the rules of civil procedure and in the tax court, Rule 70, but various jurisdictions have different rules about how work product applies and in what test. And it isn't a standard test across the board for taxpayers, unfortunately. But in anticipation of litigation, that term litigation can also include in an audit and preparing for an audit, preparing for a battle against the IRS. And when you have your tax advice from a tax practitioner or lawyer that discusses the IRS's position and what arguments they might make and how you might uphold a tax position if it's challenged in an audit and potential litigation, those documents should be covered by the work product protection. And so we want to talk about that. Also relevant to this discussion is in the dual purpose document discussion that came up in grand jury, excuse me. That dual purpose analysis is often in the context of work product and not attorney-client privilege. It's often the question really is a dual purpose document that has a litigation purpose as well as a business purpose, whether that document is covered by work product. That's most often the query. It doesn't relate to attorney-client privilege. So it's interesting to see how the discussion evolve in this case and in the oral arguments. I think we're going to move to the next slide. We wanted to note here.
Before we go there, that last point, Denise, is very well taken. Because you see different circuits actually do have different opinions. I mean, if you want to look at Textron, look how that ended up with the government win. And then there's this little 11th Circuit case that really never got to the 11th Circuit because the government backed down. They didn't want to go to 11th Circuit. But if you look at a case called Regions Bank out of Alabama, it was going to go to the 11th Circuit, and the government decided at the last second not to appeal it because they were afraid of. They were concerned, not to use the word afraid, but there was a concern whether they would be able to prevail and put the issue before the Supreme Court when they had just prevailed in Textron. So apologies. As Denise said, on to the next slide.
Thank you, Jim. So we want to note here just the basics of waiver, and this slide is in the context of work product, the issues elaborated in the rules of evidence. Work product waiver is more narrow than attorney-client privilege waiver and tax practitioner privilege waiver, which is broad. If you produce that document, even inadvertently, in some instances, to any person outside of the privileged parties, there's a waiver, and that waiver is potentially a subject matter waiver that could be very broad. Whereas in the context of work product, if you produce a document to someone outside of the privileged parties, it's not necessarily waived. It would be waived if that party is an opponent, or if that document is now more easily put into the hands of an opponent. And so this is demonstrated through a pretty recent case where for example, and I'll be brief, but because I know we want to get into the issues, but where an attorney-client privilege could potentially be waived when an attorney asks a clerk at the front desk of her hotel to print some documents. That could potentially be a waiver of attorney-client privilege. You have a third party who now has access to privileged communications and could end up in a subject matter waiver. Of course, we would make some arguments against that and try to protect the taxpayer's privilege there. But I would argue that work product wouldn't be waived there. This clerk at the desk of a hotel is not an opponent, and it doesn't put the document in the opponent's hands more easily. And so that just hopefully gives a picture of how waiver is different for work product.
Yeah, I think you also mentioned something that bears a little clarification, Denise. There's a difference between an affirmative use of a document, the classic example in the tax area being a penalty opinion as a defense for reasonable cause of penalties. Affirmative use is usually taken to be a subject matter waiver. That is, once you've opened it up or you're relying on that advice, all the communications about that advice become relevant and discoverable under both attorney-client and work product generally. Whereas an inadvertent waiver or a narrow one document waiver may not be an affirmative use. It may just be waiver with respect to that one document. And under the federal rules and now under the tax court rules as all, there may be clawback possibilities for that as well. But an affirmative use almost always results in a subject matter waiver of the whole subject matter of the communications.
Yeah, that's a great point. It's a great point, Chris. I think if we move to the next slide, I think we wanted to get into that actually and talk about affirmative use and talk about this particular case, add investment, or can you move to slide 16?
There you go. Yeah. So if you want, Denise, let me give the audience the background to add investment, and because for us litigators, facts are important. There's the old adage: if you don't have the law, argue the facts. If you don't have the facts, argue the law. If you have neither the facts or the law, just pound the table. And this, in a way, is option 3, and it was done successfully by the IRS. Ad investment was written by a judge that I respect dearly, Judge Halpern. But on this one, I'll be blunt. I don't like the opinion. I think it's ripe for abuse. In this case, the fact for the IRS was seeking 6 more likely not opinion letters from a law firm. The taxpayers in their petition raised an affirmative defense as to the IRS determination as to an accuracy-related penalty based on substantial understatement of income tax. The taxpayers' allegation was simple and straightforward. There is or was substantial authority for the partnerships and its partners' tax treatment of any items resulting in an underpayment of tax. And the partnership and its partners, here are the key terms, reasonably believe that their tax treatment of such items was more likely than not. In defense to the IRS determination of an accuracy-related penalty, the petition alleged any underpayment of tax was due to reasonable cause and with respect to which the partnership and its partners acted in good faith. The court held, since taxpayers raised as an affirmative defense the legal knowledge and understanding into contention in order to establish good faith and state of mind defenses, the taxpayers waived attorney-client privilege. Now, Chris, this isn't the only case where the tax court has ruled in favor of the government on these matters. There's a case that you mentioned to us yesterday when we were discussing the matter. It's an order, and the name of the case is Eaton. Do you have any thoughts as to Eaton?
Yeah, it's a similar holding, and it keeps pushing this notion a little bit further. In the Eaton Corp, they did have legal opinions, but they weren't asserting reliance on advice of counsel as part of their reasonable cause defense. They just said, well, we think we have reasonable cause. And the court in in Eaton Corp writes in an order that's it's a reported order, but you have to know the docket number, which is 5576-12. It's a little tricky to find, but it was May 11th of 2015. The court in that order said, well, reasonable cause puts your state of mind at issue, whether there's legal opinions or not. Your state of mind is at issue, and all communications with respect to that are relevant to what you were thinking when you did this transaction or took this tax position are relevant. And that includes the attorney-client privilege. That includes the attorney opinions, and you've effectively waived attorney-client privilege simply by asserting reasonable cause as a defense to the penalties, which I found shocking, frankly.
Right. So for Chris and Denise, what are the ramifications? I mean, what's the big deal? So I have to turn over the opinion. That's it, right? That's all they get? Do they get anything more?
All communications, according to the Eaton Corp opinion, anytime you were talking about it, that's relevant to what your state of mind is.
So all, Denise, mean what? Is that meaning emails? What's all mean?
All is really all emails, documents, everything that would contain any type of advice, which is every single email between your accounting firm, your lawyer, your in-house counsel. It's a huge privilege review, really undertaking to make that determination. And we've certainly been in cases where the government asserts a penalty and seeks all that tax advice and wants that advice, and our job is to keep that protected. And most certainly, in one instance, which just really puts the emphasis here, we actually offered the government the tax opinion. 263-page tax opinion by EY offered that as a limited waiver of our privileges and protections. And the government refused that offer and didn't want it. They wanted every single email. They wanted everything else. And they fought that all the way up to the Second Circuit where we won. But they weren't willing to accept any limited waiver where they got a 200-page roadmap of the taxpayer's position.
And that for me is the concern. These opinions allow the government a tremendous amount of access into the conversations, and what would normally be viewed in any other area would be viewed as privileged material. And all the government, this is the concern that I have, all the government has to do is go under 6662, raise the penalty, and then the taxpayer's got to come up with a defense. And once he says, I have reasonable cause, and if you look at Eaton and if you look at AD investment, there's a danger, and that the government's going to try to get everything. And I do mean that, not just the opinion, but all the underlying work papers, emails, and discussions. Am I going too far?
No. I was just going to make a point. I didn't mean to interrupt you, Jim, but the point is, even without asserting privileges, in many cases, actually, the government would just issue a summons, and skip penalties, issue a summons, and now you've got to assert your privileges and undergo a huge privilege review to protect those documents.
Yeah, what this has the effect of doing, Jim, I think, is it eviscerates the reasonable cause defense. Yes. Or it certainly means if you have a reasonable cause defense and you want to assert it, you can only do that if you're willing to have every thought or discussion about the issue revealed to the government, which seemed, and I mean, that's exactly what the Eden Corp order says. It says the documents the respondent seeks are directly relevant to petitioner's penalty defense in that they provide some evidence of petitioner's experience, knowledge, the data that was relied upon, and how it was analyzed. It would be unfair to permit petitioner to proceed with this defense and denying the government the access to that information. I have a problem with that. That means that reasonable cause only exists if you're willing to discuss or to have every single conversation about the issue examined by the government.
Right. And that's where I find it to be, and we'll get there, we promise, folks. This is why we first started off with Upjohn. And that is, what is the difference between Upjohn and what lawyers do in terms of tax? And then towards the end, we will make sure that we come up with, what are our suggestions, and then we'll have Denise and Chris offer their opinions as to how do we go about trying to preserve whatever privileges we do have after the great punt by the Supreme Court. So let's see if we can go on then to the next slide.
Yeah, I just want to make one point about this next slide, which is there's a way the courts could avoid this, and many taxpayers have tried, which is let the taxpayer try its liability case first without giving away the roadmap to the government about its defense, and try the defenses only if the government can prevail on its own in the litigation. You shouldn't have to waive privilege to try in order to get to the point of trying your case, before you know whether you even have a liability and a penalty. So I think that bifurcation would be preferable. And the courts here have said, and these couple of opinions saying that the tax court is also very got a number of very strong opinions on this, that you get to choose. You can either assert a privilege or you can show us everything. And as soon as the IRS asserts a penalty, you're put to that choice.
Right. So you're saying, Chris, the best way to do it to avoid these where the government has your, for lack of a better way of saying it, the playbook in its hands is to bifurcate the issue. That would be
I think
fair.
that would solve, that would be fair in my view. It wouldn't require you to waive privilege every time the IRS adjusts an issue and
Right.
says, oh, by the way, we're going to assert a penalty so we get to see everything.
Right, because I mean, we've all done FOIA actions and we all seen the responses from when we do a FOIA action. You're going to get attorney-client privilege, you're going to get work product, you're going to get deliberative privilege. This seems to be an executive privilege. But when it comes to the taxpayer trying to raise a privileged defense, the government says, no, we're entitled to it. When we ask that from the government, you get 20,000 type of privilege or defenses coming. It seems to be a one-way street. I mean, all you have to do is look at the, just like I said, FOIA, see what they do, the great work done by tax analysts in terms of trying to get those documentations, and just see what the government raises. So it seems to be one direction and one direction only. And that's, that's one of my biggest complaints in terms of, and we're going to get there, as to how the issue was framed in Ray grand jury. So why don't we then jump really quick to one more slide in terms of what I call the basics of what was in dispute as to in Ray grand jury. And for us, a key case in this whole matter, and if you read the transcripts and you read the briefs that were submitted in Ray grand jury, is a case that Judge Posner is viewed as a legal giant. But on this one, it tells me even great judges have bad days. So Frederick, which is cited repeatedly by the government, no matter what circuit you're in, they always cite Frederick. So what are the facts in Frederick? The IRS sought to enforce a summons as to Mr. Frederick regarding his clients. Now, Mr. Frederick happened to be a lawyer and accountant, and he provided both legal representation, and he also prepared returns for the individual shareholders and their company. He did not comply with the summons. He said, I'm subject to the attorney-client privilege or the work product privilege or both. So then Judge Posner in his decision said, well, let's look at the documentations at issue. And he says they're created in connection with the preparation of the individual returns. There's draft of the returns, there's worksheets containing financial data, and there's correspondence. And then comes in dicta, and I do emphasize that this was not the holding, this is in dicta. He says these are the kind of documents that accountants and others prepare and generate an incident to preparing a client's returns, or that taxpayers themselves generate when preparing their own returns. And we must not allow a taxpayer, by hiring a lawyer, to do work that an accountant or their tax preparer or taxpayer himself would normally do, and obtain a greater protection from government investigators than a taxpayer who did not use a lawyer as his return. To rule otherwise would impede tax investigations. However, Judge Posner did not accept the government's argument that there is no issue of privilege. He also rejected the government's argument that numerical information can never fall within the attorney-client or work product privilege. He says individuals undoubtedly benefit from having the lawyers do the returns, but they must take the bad with the good. If his legal thinking infects his worksheets, that does not cast a cloak of privilege over those worksheets. They're still accounted to worksheets, unprotected no matter who prepares them. Put it differently, a dual purpose document, a document prepared for use in preparing tax returns or for use in litigation is not privilege. Otherwise, people in or contemplating litigation would be able to invoke, in effect, an accountant's privilege, provided that they use their lawyers to fill out the returns. As this section 7525, nothing new in the statute suggests that these non-lawyer practitioners are entitled to a privilege when they are doing other than lawyers' work, and so the statute would not change our analysis. Chris, Denise, what, if anything, do you like about the Frederick opinion?
Well, it got the holding on the applicability of 7525 right, because it was an effective date holding, and that was correct. But a lot of this dicta restates or summarizes, in Judge Posner's words, case law that's out there, which basically boils down to communications regarding return preparation are not privileged. That's the way the IRS and the DOJ like to synopsize that. But if you scrape away at the behind those cases, they basically come down to two rationales. One of which is waiver. And the waiver rationale is kind of silly because when they say, well, you either waived it when you gave the return, you waived all your communications about the return when you gave the return to the government, or you never intended it to be confidential in the first place, which is an element of attorney-client privilege, because you knew you were going to provide it to the government. But that doesn't work when the documented issue is a contract or a draft contract or a letter to your opponent in non-tax litigation. It makes no sense to say that in those circumstances, because I know I'm sending the contract to my opponent, that all my communications with my client about it are waived. That's a silly argument, really is. And yet courts have fallen for it. And it's only because they haven't really been thoughtfully presented with the argument against it, in my view. Right. The other argument is that it's just not legal work, as if what a lawyer does in connection with a tax return, when I get a client who asks me, is this reportable? What's my procedural options? Should I put a disclosure on it? Can you help me write the disclosure? As if those communications are the same as adding up a column of figures and putting them in a box on the return. And they're clearly different. They're clearly different. I don't do returns. I advised when I was general counsel of my firm, don't do returns. We don't do returns. That's accounting work. I keep your accounting separate from, and your return prep separate from your legal advice. And Denise, can you tell me how that works out in practice?
Yeah, sure. So practically, I think all three of us and probably many people on the line would not necessarily agree with the dicta in FEDRIC and how it's been applied for the last, couple decades, particularly just really, really brushing aside return preparation, as you say, and everything that goes into it as not confidential, not privileged or waived, as you say. But it is the framework under which we have to work, right? And from a practical perspective, of course, the three of us will be there to argue a case where, we clearly feel pretty passionate about the extension of privilege and how it should apply. But just in terms of what is a best practice today under the framework we are working under, I advise, and I think we all advise our clients to make a best effort to segregate those files. And when you have a tax practitioner or a lawyer involved in your return preparation, drawing very distinct lines on what is tax advice, even within a CPA and within your accountant's work. They should have a return prep file. They should have documents that are necessary to support the return in there, and then a tax advice file, which would be, protected by 7525 and or the privilege if they're working with outside lawyers and the client's lawyers on issues that is really tax advice and not just return preparation. And so that's really the best way to deal with it in today's world. Dealing with the framework that we have is to keep those files segregated. Now I know that's a lot easier said than done, and believe me, I've been, I've led the team where it takes several days to figure out which bucket a document or a series of documents might go in, and whether there needs to be redaction, or how we treat all these documents. Where you have an accounting firm preparing a return, there's certain tax advice that might be that might go into why a certain position is taken on a return, and drawing that line between what goes in the return prep file versus the tax advice file.
I think that's perfect advice, Denise. That's right on point. Before I forget, now is the time for me to give the code for anyone licensed in New York or listening via phone. The code is HK230425 4343. Again, HK230425 4343. All right. So let's now just jump into real quick into and I'm going to, because of our time constraint, I'm going to quickly just summarize the facts. in a grand jury. There's a federal grand jury is conducting a federal investigation of client. And he's an early promoter of Bitcoin. He expatriated from the United States in early 2014. He retains a law firm to provide advice on the expatriation process. He also retains a law firm to prepare his 2014 return, which is filed in mid-2016. Grand jury subpoenas the law firm. The law firm provides over 1,600 documents, withholds 54 documents invoking the attorney-client privilege and the work product. The government moves to compel. The lower court, the district court says that's the 54 documents. We're going to apply the primary test. The law firm appeals the order, and it goes up to the Court of Appeals, and the Court of Appeals affirms the primary purpose test. Next slide, please. Next slide. Yeah, all right. So this is, for me, the most important aspect of the case. The issue that was submitted to the Supreme Court was, as it reads there, whether communication involving both legal and non-legal advice, a dual purpose, is protected by the attorney-client privilege. I'm going to start off with Chris. Chris, is that the way the issue should have been framed, or would you have stated the issue another way?
Well, I probably would have tried to state it another way. I mean, it may have come out of the district court or the Court of Appeals this way, but I think implicit in this phrasing of the issue is the assumption with which I just explained I don't agree, notwithstanding there's courts out that have held this way. But the assumption that all communications with respect to return preparation are never privileged, either because they're not legal work, they're accounting work, or because they're of those waiver arguments. And I had hoped for this case that issue would have been squarely presented. For whatever reason, it's not how it got framed before the Supreme Court. And so this is a classic example to me of, if you an old trial lawyer's adage, if you ask the wrong question, you're going to get the wrong answer, and I am an old trial lawyer, so I know that. That's kind of what I had hoped I'd hoped we'd get a clarification of the kind of activities with respect to return preparation that are or are not privileged. And instead, the question was framed as, if they're both, how do you decide? How do you balance that? The primary purpose, secondary purpose, tertiary purpose, the 55th purpose? I don't know. I don't think that actually confronts the core question. I'll stop there.
Denise, do you have any thoughts?
Yeah, I mean, I would tend to agree with what Chris just said, and I would also say that it seems as though the facts didn't really support the type of finding that we were looking for, and as the law firm is asking the court to extend the attorney-client privilege to dual purpose documents that contain, that also contain non-legal advice. And what's peculiar here is, most of us lawyers would not say that we're providing non-legal advice, and we wouldn't have 1,600 documents to produce of non-legal relevant advice. I mean, if there is any non-legal advice in my files, or it most likely would be non-responsive, right? Some type of business meeting or something that's not relevant. So that's sort of peculiar to me. But then, we also have these 54 documents that also have non-legal advice. And I think we just really missed the issue here with documents that could easily be redacted. And so in part, the facts didn't really support the court really taking a look at the real issues here that are important and are a very muddied area of the law that does need clarity.
Right. And we're going to get to the next slide pretty soon, which is going to demonstrate that. I believe the way the issue was framed basically capitulated to the notion that the practice of tax law is not necessarily the practice of law. And this then creates the confusion that came out in the parties' briefs and in the parties' oral arguments. And when you look at the parties' briefs, the law firm started off with the significant purpose test and relying on Kellogg Brown, which Judge Kavanaugh was the primary author. And when applying the primary purpose test, he says, well, that's too narrow. As long as there's a significant purpose, that should be the quote unquote test that when you're looking at these structures. The U.S. government came back and argued the primary purpose test. And that is, if you're looking at dual purpose, were they seeking, was the primary purpose one to seek a legal opinion or not? And Chris, I'd like to get your views because I really think, and we had the discussion with the amicus filed by the ABA just caused, in my humble opinion, because it did not address the fundamental issue. Rather, it came up with a new test that really caused confusion amongst the court and amongst the party. And that is, they came in with a very open test, which is, as long as it's a good faith and you're seeking legal advice and you're doing it in good faith, well, then these privileges, no matter what you want to call them, whether it be the primary purpose or the significant purpose test, don't put captions on it. Just allow the entire document or the entire contested phrase, let it in. Now, how do you view what the amicus was trying to achieve?
Well, we're all operating in some vacuum because we don't have the actual documents in front of us. But when I write an email to a client that says, no, the provision you're worried about doesn't apply, there's a carve out for it, you don't have to apply that here, you don't even need to write a disclosure, go ahead and put that on your return. Let's just say I have that email. What part of that is not legal advice is my question. And I think the ABA's brief, which I actually liked, I think more than you did, tried to put that issue in focus. And as Denise was saying, we're sort of at a loss here because there were 1,600 documents produced. Maybe they were discussing, it was cryptocurrency, right? Which exchange to trade on, or what the pricing of this cryptocurrency should be, or something that's purely a business issue. But if they were discussing how do you report it on a tax return, which is the kind of communications most lawyers have with respect to return preparation when they get a question from a client, I don't see how that's not completely legal advice. I don't see what part of that is business advice in the first place. And I think in kind of a flip order, that's what the ABA was trying to say, is whenever there's legal advice in there, the fact that they also have a business reason for asking, well, every client has a business reason for asking, right, that shouldn't taint it and say, oh, therefore it's not legal advice.
Right. Right. So I agree with you. The problem is, though, I think with the Supreme Court was coming in here thinking we have two different standards. It's a primary or is a significant purpose based on with Judge Kavanaugh, because he's there sitting on the Supreme Court. And all of a sudden, here comes the ABA and say, Your Honor, without telling you really what the issue is, because I think the ABA wanted to say tax law is the practice of law, and therefore everything comes in. You can look at two ways. They dropped it on the court, and the court then realized, oh crap, this truly is the issue, and the best thing to do is run away from this mess, because we don't want to give you an opinion on it. And we got all this jurisprudence out there saying repeatedly over and over, what accountants do is not the practice of law. We don't want to step into that mess. Or they got confused as to what is the appropriate standard. Because if we go to the next slide, I'll give credit to the government. The government saw what was going on. And what I found when you look at the oral arguments, I thought the government basically did a tremendous job, because she said one statement, you know what, Your Honor, there really isn't much of a difference. And if you rule for us, as long as you say the appropriate test is a primary purpose test, but you apply a significant purpose behind it, we're fine with it. And that caused the judges go, what are we talking about here? So then they would look at the appellant here, and say, so what is your test? And when he came back and said, well, we want this new test called good faith, I think, Chris, to your point, and to your point, Denise, is they saw that what the real issue was not really what they thought they were getting, but now they had a brand new issue before them, and they didn't want anything to do with it. Chris, Denise, your thoughts?
Go ahead, Denise.
Yeah, and I think that's a good point, Jim. And I think that we have here really comes to this question of when you get into the two different tests, there's all sorts of case law on this, right? And different appellate courts apply the test differently. And as I said, a lot of times in the work product context. But I would argue, I think Chris and Jim would probably agree with me that anytime a client calls me or sends me an email as a tax lawyer, that their primary purpose is to seek legal advice. And I find it hard to believe that even under the highest standard that wouldn't be protected legal advice under the attorney-client privilege.
Yeah, if they're asking business advice of me, by the way, they're going to the wrong person. Okay. So I agree with that completely, Denise. And I do think Jim's partly right that the reason the the Supreme Court kind of punted on this issue is because remember the Ninth Circuit had a footnote in its case, in its first opinion, that said, well, of course, tax return preparation or tax advice is generally not legal advice. And the bar went crazy and called it to the court's attention, and the court deleted that footnote. But that concept infects the underlying opinion. And I think when it got to the Supreme Court, as I think the next slide shows, they just decided we don't want to wade into that thicket. And so if it ain't broke, don't fix it, as Justice Kagan said.
Right.
We're not going to go there. We're just going to say, well, we don't need to decide this because there's not that big a disagreement over the primary purpose versus significant purpose. It's just how legal is this? And if it's legal advice, it's legal advice. If it's business advice, it's business advice. Right. And so they sidestepped the issue a little bit by dismissing as improvidently granted.
So let's go to the last slide, and I'm going to open this up. If you want this issue to be litigated, let's say the IRS comes back, whether they assert the penalty or not, and they ask for all your documentation. Give me all your documentation, your legal opinions and so forth. We've all seen those IDRs. And you're like, no, I believe this is truly privileged. What is it that you would do, Chris, if your client comes up to you and goes, I don't want to give it to them. I think they're full. I think these decisions are just flat out wrong. What would be their recourse?
Yeah, well, most people don't want to pick the fight if they can avoid it. And you can sometimes, at least in most discovery situations, decline to produce it, run the risk of a contempt citation for failure to obey a court order to produce it, and tee the issue up. But first, you try and brief it with the trial court year before. Say, look, I know those holdings are out there, that return preparation is generally held not to be legal advice. But Judge, I'm going to show you these documents in camera. They don't discuss tallying up numbers to put them on a return. They discuss the legal issues in my client complying with a statute. That's classic legal advice. And just because it's in a return preparation context shouldn't mean that those other cases that say it's not legal advice apply. I think at some point people have to start taking that chance with the courts. And as I said, if you really feel like you need to fight it out and that the advice should not be given ultimately to the government, the way that there's ways to do it. You seek in-camera review. If you can't get that, you get you decline to produce it and get an order against you, and then you appeal that. Those are almost always immediately appealable. That's what actually was going on in grade grand jury. So I mean, there's ways to tee what to my view is the correct legal issue up. But most clients are not going to want that risk because they ultimately come to the conclusion, what the heck, we'll just give it up, you know? And I think that's what happened to even some of the documents here, as Denise noted, 1,600 emails or documents from a law firm that they gave up. I don't know what they were talking about in there, but looks like they had conceded an awful lot.
Denise, thoughts?
Yeah, I mean, I really spoke to that. I think Jim earlier, agree with Chris on that. I think it would require the right facts. And to me, the fact that the Supreme Court took this case means that they were interested in this issue. And I think, as you say, Jim, maybe the issue just evolved and went down the wrong path with the wrong fact. And unfortunately, they weren't able to make a decision. But I would like to see a case where they are able to look at tax advice and parse out return preparation and where that line is, because it is pretty vague right now for most taxpayers.
Right. I agree with that. Well, both what you said. I mean, like I said, that lawyers like to argue the facts. If they don't have the facts, they argue the law. All right. So if you have the great facts, and I think we all agree, it's got to be framed in the right issue. So if you have the right facts, you can frame it. Is this the practice of law or not? And force the government to come back and say, no, we believe that tax is not the practice of law. And then the question will be based on the facts that we have, the communications with the attorneys saying, I have this occurring, and you're giving a purely legal opinion. I would love to see that case go forward, no matter what jurisdiction, because I think that would be the case that the Supreme Court does look at it, not as is this the primary purpose or significant purpose, but it actually addresses the issue that we all want to address. And that is, what is the Supreme Court's take on tax? Is it legal or not? You can't come up to me and say that under Mayo, tax is not special anymore, and then turn around and saying, yeah, tax is nothing more than in the back burner because it's not really the practice of law. And then when I go to a district court, I hear from the same judge saying that the most complex area, the one they never want to see, is tax law. What is it? And with that, I'll give you guys, Chris and Denise, closing remarks.
Yeah, my just thought is people need to stop just thinking about return preparation and think of it more broadly. My contract example, my letter example. To give another one, is securities law privileged or not? Conversations about securities law privileged or not? Well, everyone has to file, every public corporation has to file 10Ks and 10Qs, 8Qs, that sort of thing. If I advise a client about those, that communication would be privileged, wouldn't it? Well, what's the difference with a tax return? In fact, as Jim points out, tax returns are pretty complicated. There's lots of judgment calls involved. There's lots of need for legal advice. I would just hope that other people confronting this question would think about it in slightly different terms and maybe think that maybe this is an issue that there should be more legal analysis on by the courts rather than just a knee-jerk reaction. It's return preparation. It's not privileged.
Denise, you get the last word.
That's great, Chris. And I guess for the last word, I would probably just keep it practical and say, let's be careful about what we do put in those emails, whatever's in those 1,600 emails, I don't know. But let's be careful what we put in email, and let's make sure that when we're providing tax advice that it's distinguished from return preparation, and do our best to draw that line and to have, I know there's a lot of CPAs on the line as practitioners to be clear about what we're providing. Is this return prep? Is it just going to support the return, or is this something more than that? And should I put it somewhere else? And for now, that's where we are. Just like Chris and Jim, I hope that we can challenge this and challenge the law, and hopefully the Supreme Court will take the real issue up at some point. But for now, I think we do our best to work under this framework by segregating our documents and being clear about who we're hiring for what purpose and what our the purpose of our communications and documents.
I think that's good advice.
And with that, I think we are done. We appreciate everybody attending this conference. And of course, we appreciate Chris Rizek from Caplin Drysdale joining us for this presentation. And again, thank you very much and have a great day.